Welcome to our next panel discussion. This is our All That Glitters Is Not Gold panel. We're going to talk about Ponzi schemes and techniques and tips used in resolving and dealing with Ponzi schemes.
This is not a how-to panel.
It's not a how-to. Sorry, it's not a how-to panel.
How to collect the money.
How to resolve, not structure, I guess. I'm Tom Halls. I'm a bureau chief for Delaware with Reuters, and I guess we'll just go down the line here. Start with Mark.
I'm Mark Carmel. I'm a director at Longford Capital Management. We provide litigation funding, and I think I'll end up popping in later after we figure out all the problems with Ponzi schemes. I'll help figure out one of the solutions.
My name is Chris Sanchi. I'm a bankruptcy judge in Delaware.
My name is Kathy Reese. I am an attorney at Fenimore Craig in the Mountain States, Arizona, Nevada, Colorado. But because it's where the elderly live and tend to retire to, there are a lot of Ponzi scheme cases that take place out there. And so I've had the opportunity and the privilege of representing victims, various classes of victims in these Ponzi scheme cases. Some of the largest cases in Arizona have been Ponzi schemes.
I'm Joe Luzinski. I work with Development Specialist Inc., a workout restructuring firm. I live in the fine state of Florida, which is a mecca for frauds and financial problems. I've been in the workout business here for 30 years, and I could tell great war stories if anyone would like to have a drink and have a few laughs at some point during the evening.
Joe, do you want to start and just sort of walk us through sort of like what describe your typical Ponzi scheme to us and some of the great Ponzi schemes of the past?
Yeah, I'd like to throw out a few just points of, there's the person, the business, the targets, the supporting cast. Person. You have folks that are maybe not household names, but probably household names in this room. The Bernie Madoffs, the Mark Dryers, the Tom Petters, the Lou Pearlmans, that all very, very astute, type A, overachieving business people, had some nexus to a good business or a real business. Somehow that morphed into needing more, better, higher, bigger, and in a word to describe these people, some would call them manipulative, some would call them immoral, pathological liar comes to mind, narcissistic, sociopath, immoral, but this seems to be thematic of the person. So as it relates to the business, it's a crapshoot with Ponzi's. Sometimes there's a real business, and oftentimes there's not. So, the core asset value, how you approach it, how you manage it, how you restructure it if it's restructurable, or how you recover money for clients, is really wholly dependent on, is this a Madoff type scheme where you're just leveraging dollars over time, or is it a business that leveraged real estate or something where there's actually some underlying assets and some value there that can possibly be restructured or recovered. And ultimately, they all involve an element of what I would refer to as the whisper, which is, you have to know somebody to get in, you have to want to get in. It's the country club, it's the synagogue, it's the church. People curry favor. Madoff had feeder funds. I live in Fort Lauderdale, and I have friends and acquaintances who invested in Madoff because there was a big feeder fund in Fort Lauderdale that drove Madoff. Obviously, there were a number of Palm Beach folks who were similarly situated, but this is the structure of creating that need and filling it, meaning incenting people to want to get in. So who are the targets? Well, it varies by scheme. In Dryer, the targets were hedge funds. They're very sophisticated investors drafting 50-page contracts to buy interest in these notes that Dryer was fabricating, and obviously fabricated out of thin air. So really no value there. In other areas, you have wealthy individuals who are investing hundreds of millions or hundreds of thousands of dollars, depending on their stature and depending on what the scheme is. But it goes down to even retail type investors where, in Miami, there have been several scams of recent vintage of in the Haitian community or in the Hispanic community where people are doing deals of, $2,000 investors, but they're more retail. So there's thousands of them instead of hundreds of them. And so, it varies across the spectrum. So going back to the business for a second, the other one of the other facets that you see a lot in these financial scams is the supporting cast. Who are the people that are helping? Because at some level, these things get big enough where the schemer cannot do it all himself. Bernie Madoff could not do it all himself. Mark Dreyer could not do it all himself. So they tend to bring in salesmen that are highly paid if they're selling something, high returns, getting other people to draw others in. On an individual basis, it's easy to administer these scams when they're small. When they get bigger, you need help. Schemers typically have, the bookkeeper starts out as the bookkeeper, and then the company grows prolifically, and you still have a bookkeeper running the place. You don't have a CFO. You don't have a vice president of finance. And so that's a telltale sign of a Ponzi when you've got people of limited resume skill operating a significant business. The reporting structures are typically very flat. Mr. Big does everything. He signs the checks, he approves everything, and various disciplines that would normally in a business talk to each other don't talk to each other. I was involved in a scheme where finance and accounting were in different floors and different places, and they couldn't talk to each other. They were not allowed, even though they had seemingly some similar nexus to each other. So. And finally, these structures are typically very, again, going back to the person, controlling, manipulative, narcissistic, and oftentimes people who are working for these folks have a pretty good sense of what's going on, but they're getting paid a reasonable amount of money, and they're happy to keep their blinders on. So that kind of sets the stage for the next level.
What tends to expose the Ponzi and bring the Ponzi to an end?
Depending on the type of business, sometimes it is a rising economy, and when the economy drops, there's no more money left to feed the beast. Sometimes it's happenstance. Sometimes it's a regulator that for the 11th time says, okay, maybe we really should take a look at this guy. We've gotten another complaint. There oftentimes are many complaints about these people, but a la Madoff, they're able to successfully fend them off and show the regulators or con the regulators too into putting a note in the file that they saw and they didn't see a problem.
And sometimes it's a whistleblower. Within the organization where you indicated there are staffs and there are layers of staff, and the principal at the top is the one who's the major decision maker, of course, for the indictment. He's the target as well. But there are people underneath that are the whistleblowers who maybe they're still making the commission, but they know there's just something not right. They don't see the whole picture. But when they start to see the whole picture, they really have a conscience and they come forward. And the SEC and the various state regulatory agencies, particularly in my part of the country where you're dealing with the affinity fraud type cases, where you have a huge level of trust and friendship, and that's how the scammer gets the individual to invest because of that affinity and that relationship, whether it's the Jewish community, the Mormon community. It's very active in the Mormon community in that part of the country, or the professional athletes. That also is another group that has been targeted, the Greeks. There are just a number of affinity groups where they're able to be brought in because of that trust. But then they start talking to the press, and the press sometimes have done a really good job in trying to figure out through their investigative research some of the issues that are there, and they're able to then bring it to the attention of the regulators. The regulators then oftentimes will step in because you don't mess with Texas, you don't mess with the elderly in Arizona, you're going to end up going to prison if you really take advantage of it and steal the money. And so sometimes, as I said, whistleblowers, sometimes the press, and sometimes the agencies.
So it comes undone, the whole thing comes unglued, regulators step in. Sort of what typically plays out at that point?
There are a lot of different stages in these cases. There are like 5 different stages within the whole Ponzi scheme type of a case. But the first one is really where is it going to proceed? Because the state or the federal government steps in with a receiver for the cease and desist the activity, so that whether it's a pyramid scheme, whether it's the or a securities type of a case, they end up helping to stop the activity and the current activity, or at least temporarily. And oftentimes the debtors then end up going into a bankruptcy. They don't really want a receiver to step in and take over, a federal equity receiver or a state court receiver. So instead, the company ends up filing a Chapter 11. And so the question is, where are these things going to be litigated? Because bankruptcy is one avenue, one venue that you could choose, but you could easily do it in a receivership in either one of those courts, the state or federal. And you can also, I've seen debtors try and attempt to do it through an assignment for the benefit of creditors. They get to pick the assignee for the assignment of benefit of creditors. They assign all the assets in, and because those are state law creatures, oftentimes states don't have preference. They have fraudulent transfer laws, but they don't have preference laws. And so there is, a reason why the debtor would pick an assignee instead, and there's not as much litigation when you deal with an ABC. But it's another type of form. Those are the ones that they end up picking. But usually it ends up in bankruptcy court because it has the most remedies, it has the most procedures to take care of the issues, and in those rare cases, as we were talking about, where there's real estate, a significant amount of real estate, whether it's the Woodbridge case, or whether it is the Mortgages Limited case where I had represented the investors and now represent and work on the trust side, liquidating everything. If you have something where you need the assistance of the court, you're able to have the court help you sell those assets and manage them.
So it goes into a bankruptcy, it goes into Chapter 11. Judge Slanchi, what are sort of the things you want to, would the court want to address and resolve as quickly as possible?
Right. Well, anytime there's allegations of fraud in a new case, you're probably going to see some motion activity very, very early in the case. And it would be a motion to dismiss, perhaps, or more likely a motion to appoint a trustee because of the allegations of fraud, current management has lost the trust of at least some of the creditors or stakeholders. The problem, though, is from a judge's standpoint, you can't just take it all at face value because every case I get that has public shareholders, I get lots and lots of letters about how it has to have been a fraud. How could this happen in America? You have to fix this, appoint a trustee, et cetera, et cetera. And usually it's not fraud. Usually it's just a bad market situation or just bad management, but being a bad businessman is not being a fraudster. So you kind of have to take it a little bit, all right, well, let's see how it plays out, and the evidence is going to matter. But once you get the idea that there's actual fraud allegations that have some legs under them, I think one of the most important things the judge has to do is figure out a way to restore trust in the business, or really trust in the management or trust in the bankruptcy process. So that's where appointing a Chapter 11 trustee might be appropriate, or what they did in Woodbridge, at least for a little while, which was appointing special directors. It was sort of really a gold, plated board. They put Jim Peck, Bob Gerber, and Jan Baker as a special committee to try to they were trying to wrestle away the trustee motion, and one of the ways they tried to do that was put together a group that would be in charge that people could trust. So it doesn't necessarily have to be a trustee, but once you see that there's this, allegations of fraud with some legs under it, you really have to come up with a way to put some trust in whoever the debtor in possession / trustee is going to be. And I need that trust. I need to be able to believe what the debtor is telling me. Or whether it's a trustee or a debtor or a special committee, in order to make the case function. And the creditors need to have buy-in on the legitimacy of the bankruptcy, and that requires having some sort of buy-in on management. So I think you have to deal with that. Once you have to be careful because it's not always fraud. It usually isn't. But if it is fraud, you need to act quickly to restore integrity to management and the bankruptcy process, either through the appointment of a trustee or a special committee or some sort of mechanism to restore trust. And
Judge, as you've said before, the individuals have already been victimized once by the fraud, by the Ponzi scheme, by the pyramid scheme, by the affinity fraud that's taken place, and they don't need to be victimized by the process. So I thought that was an interesting observation you and I talked about.
Yeah, it's very important that the creditors and investors and victims have buy-in, and unrelated case, but when you have tort cases, it's all about tort claimants. Whether it's a diocese case where you have sexual abuse victims, or a case like Takata where you have people who may be injured by the bad airbags, you have to get the buy-in and trust with that group. They have to trust the judge. They have to trust the process that the court's running in order for the reorganization to be successful.
And that's why I liked in the Woodbridge case the order that you were just talking about. While the gold standard group was not ultimately the one that stayed in, there was a new gold standard group too, I guess, with I think DSI staying in as the CRO. So the point is that in that one, what I liked about the order that was entered in that case that was negotiated by the parties is that you did have the buy-in of the constituency groups. You had the ad hoc unit holders that then had seats on the committee that then was formed. And then you had the buy-in of the note holders which shared seats on that committee. Then you had the unsecured. So through the process, you ended up having the major constituency groups that really need to be actively involved in finding the solution and in buying into the solution.
Yeah, because it doesn't have to be a Chapter 11 trustee. That can be a really blunt weapon. And the problem with a Chapter 11 trustee who still has an active corrupt board is who's instructing whom on what to do, because you could run into power struggles over who's really controlling the business. So something that's cooperative and creative can often be better.
So you get it into court, most likely. You get hopefully the corporate governance structure under control, and it's something that everybody can trust. Sort of then you must have different, people who've been paid out, people who haven't been paid out. How did all that?
Yeah, I think the biggest, from my perspective as a judge, I think the biggest trick in these cases, and the Madoff case is a perfect example, where you've got creditors / victims who are also a source of assets for the estate. So I had $1 million in Madoff. I put $1 million in his funds. Over the years, I took out $2 million. I'm still sitting on a claim now of $1 million, so I'm a creditor, but I got $2 million of other people's money, so now I'm a target. So I think that's extremely complicated and hard to deal with, and figuring out, do you pursue those targets? How much do you take it, like preferences? I mean, how do you proceed? That, to me, that's the really complicating factor in trying to get to a plan or some sort of exit strategy, is figuring out how you're going to treat people who invested and were defrauded, but actually did okay and got a decent return of other people's money. So and some of them a lot, and some of them not so much, and then some people were just out altogether. The worst thing to do in a Ponzi scheme is get out late.
Yeah. Right. You want to be the first out.
You totally want to get out early.
You're still sued, but you want to be the first out. Yeah. But that does raise the question of the worst thing that happens in some of these cases is the groups end up fighting with each other. Mm-hmm. The victims, the creditors, the investors, they all start fighting with each other over what is going to be a limited pot of money or a limited number of assets. So to the extent that you can get those constituency groups together to talk through the issues and decide what they're going to do to resolve and to settle the differences between them, you've got to still go through the investigation and the collecting the information, because it really is going to come down to the various documentation for each of the groups. Are the note holders truly secured or not? Was it properly structured? They may have been told they had a note and an interest in a deed of trust, but it might not have been documented that way. They may have been told they had certain types of benefits and and security for it. That's why they invested, but it might not have been what the debtor actually did. And in the nursing home fraud cases that I was involved in, another kind of affinity fraud with really people that are in their 80s is just disgusting. But in those cases, the individuals, the salespeople who were highly motivated, went to the homes of these elderly people, convinced them to sell their home, put the money into the debtor, and of course it was going to be held in trust for them, and then moved to the nursing home, and then you can stay there at a reduced rate for the rest of your life. And if you ever need your money, you can move back. You can take it out and you can leave. Well, that's not what happened. And I ended up representing the Chapter 11 trustee when the lenders were ready to start foreclosing on the facilities that were there, and there was no cash, no money to buy the oxygen. nothing to protect the elderly who were there. And so it was making sure, getting back to the point, making sure you don't fight between the groups, solve your problems. I've seen solutions where they end up giving a certain higher accelerated recovery or a percentage to one group compared to the other. Or they separate out certain assets that clearly are perfected with the security interest, with the notes and the deeds of trust, so that they're able to have those liquidated separately, the equity used for the pot. And I've also been in other cases where it's all substantively consolidated because there really isn't anything.
Now, are you doing that under a plan, under a settlement agreement, in anticipation of a plan, under a structured dismissal? How is that getting done?
Well, usually it's under a plan because that is the code structure.
Right.
And you can do a settlement under a plan very easily, and you can create your trusts and different trusts if you want to. But one case I saw recently, they actually, in order to get the settlement approved, they established as an adversary proceeding a class action. And so the class action made up of these different groups then could settle with the committees and the debtor. And they did it through an adversary and then implemented it through the plan.
Who certified the class? Was that a district judge or a bankruptcy judge?
It was the bankruptcy judge making the findings up to the district court
Okay.
judge that then approved it. You're absolutely right. It wasn't a court proceeding. But there are mechanisms that you can use in order to prevent that fight. Because then the next portion of this goes to, once you've figured out the plan and how you're going to make sure that the investors don't fight with each other, then who are your other targets and where are you going? And are you going to do it through a trust or not? Because then you got to have the mechanism set up and the funding available in order to do that.
And I think that brings us to Mark.
That brings us to Mark.
Absolutely. So these Ponzi schemes and a lot of litigation and bankruptcy has one of the hallmarks of what makes litigation finance make sense, which is you've got plaintiffs who have good cases, but they don't have the money to proceed. And so one of the ways to solve that problem is to get outside money to help the plaintiffs pursue that litigation. And as a litigation funder, we're looking for good cases against defendants who can pay, where the key ingredient, which is money for legal fees and experts and other legal expenses, isn't available. We provide that financing, and in general, it's on a non-recourse basis, which may not be that much of a difference in the bankruptcy anyway, because there may not be other assets to cling to for a recovery, but we're basically getting our recovery from the proceeds of that litigation.
Can you describe what does a really good case look like to you? Like, what are the hallmarks of it?
So for a good...
Well, yeah, obviously. But
Yeah, so exactly. We're looking for cases that have, like I said, all of the necessary ingredients. So it has good plaintiffs' counsel, it has good plaintiffs with a good story, there's good case law that supports the causes of action they're bringing, and against defendants who could ultimately pay. So Joe, in the beginning of the discussion, talked about some of the key players in a Ponzi scheme. A lot of times, those players don't have deep pockets, but there are other deep pockets that may be involved. There might have been banks that facilitated the fraud. There might have been professionals that facilitated the fraud. And by the same token, there's going to be legal defenses, including like in pari delicto, that will be consistent amongst a lot of cases. And then there'll be defenses that any defendant in particular may have, that yes, they might have been the bank that was involved, but they would maybe argue that they're also a victim of this. And there could have been professionals who would say, yes, we were either the auditors or the lawyers, but we didn't know that the fraud existed. And if you look at Madoff, for example, it went on for 30 years, and it was only obviously at the end where everyone looks back at it and says, well, of course this was a fraud. And so, not to say that any particular professional or bank involved in that was either should be liable or should not be liable, but they all have different stories. And so as the litigation funder, it's our responsibility to our limited partners to basically dig deep into the facts of that case, understand the law in the particular jurisdiction. A lot of the legal causes of action are going to be state law based, so it's really understanding in what jurisdiction is this being brought, what's the relevant choice of law provisions, and what jurisdiction's law is going to be relevant, and kind of digging deep into that, and then also thinking about the jurisdiction. So sometimes these cases could be in the bankruptcy court, which for us gives us a lot of comfort because that's kind of the final resting place for where that case is going to be pursued, other than if it's in a plan that'll set out a framework for being able to pursue these actions later, as opposed to if there's an assignment for the benefit of creditors or if there's a receivership. You may end up being in another jurisdiction, and part of our underwriting process is thinking about, where is the jurisdiction, who are the parties that are going to be bringing the action, and who is going to be the arbiter, and that may change if the spot where someone's reaching out to us isn't actually a bankruptcy, because it could later end up in bankruptcy.
Right. So I assume the plan will say, the bankruptcy judge has exclusive jurisdiction over everything in the world.
Of course.
And how successful are you in actually keeping the cases in front of the judge, as opposed to he or she transferring them or removing them to district court and getting them transferred? Or
Part of it depends on the judge. The retained jurisdiction provisions in the plan are extremely important in how broad you're going to make them. If what you're dealing with or trying to sell the assets, say the real property that's involved, even once it's post-confirmation, the judge might be very willing to do the comfort orders for the sales of the real property. And if it's dealing with settlements, the judge will oftentimes be willing to approve the settlements as long as it's fully noticed out post-confirmation. But when you're dealing with the actual underlying fraudulent transfer lawsuits, many of them are going to be under state law, and some of them are going to be, because it's a longer statute of limitations, 6 years in a lot of states, or it's going to be the bankruptcy fraudulent transfer. So it depends on where it's brought, but a lot of times you have to bring it in the state court or the district court, and while they can try and get it referred to you or remove, somebody might want it referred to you, a lot of times they just want to, the defendants want to stay in the state court forum, or they want to stay in a federal court away from you. And so even if you had wanted to keep it, those are non-core proceedings, and you're not necessarily going to be able to, unless, of course, you have some great ideas for us.
I got lots to do. I am not in the work for more adversary proceedings.
Well, and most of these you'd have to do jury trials. Some of them you would have to do jury trials.
And if you've got a jury trial, if you want to do a jury trial, your circuit has to have authorized you to do jury trials. And the Third Circuit has not authorized bankruptcy judges to do jury trials.
But from a practical standpoint, a lot of these cases don't make it to trial.
Sure.
If you keep channeling people into the funnel and keep them in bankruptcy court, and the court refers them out to mediation, a lot of these things beg to be resolved, and oftentimes are. So from a practical perspective, as a debtor representative or as a fiduciary pushing these cases forward, I want to be in the bankruptcy court, because that faster docket and that back pressure keeps pressure on the defendants. They'll say, oh, we're going to remove this, we're going to do this, we're going to do that, yeah. But in the meantime, you keep pressing them into the funnel, and it works.
Yeah, I mean, mediation's a great point, and we changed our local rules just a couple months ago. We now have mandatory mediation in all adversary proceedings, subject to the judge being able to say, no, not this one. So if you were to bring 150 of these things, you could probably, at least in Delaware, and I'm sure in many other courts, you're going to run through a mandatory mediation process.
And where I can have a judge be the mediator, it's really helpful, because
it saves you money.
It saves you money, but also you can turn to the parties individually and say, well, if it were in my courtroom, I wouldn't do that. And you have the ability to have a little bit more authority and gravitas in getting the parties to a reasonable position. But this also brings up the other danger in these cases, is that there will be class actions that are brought, because the investors and the victims have their own direct causes of action, which are different from the company's causes of action, which the trust or the trustee gets, because those are derivative. So you're going to have two groups suing the same defendants for the same insurance policies in the same pot of assets. So having the class action and having the litigation trust or whoever is bringing the litigation work together and cooperate along with the regulatory agencies to maximize the information and maximize the pressure against the defendants to get them to settle, in my mind, has been very, very helpful with a couple of the examples that I've been in. And then plus that the next aspect of it is not that there's extortion, but that the states and the SEC oftentimes really are trying to bring the criminal charges. And they're on a parallel track, different from the collection of the assets and the collection. But that the criminal charges for the victims is another really important aspect of having faith in the system. And because they have been victimized and they're being re-victimized through this process that takes years. But having some sense of justice where the individuals are indicted and then they get to testify at the trial, or the victims get to testify at the sentencing, becomes a real important aspect. And I've had 3 cases where there are principals who are in jail. And the victims were the ones who ended up helping to testify. And getting back to one of Joe's first points is, what does the person who's the principal of a Ponzi scheme look like? In the nursing home fraud cases, when the gentleman got to the actual sentencing stage, he turned to the judge and said, well, I have this great deal that's going to work in Nevada, and if you just let me out and to let me work this deal, I'll get the money back to pay them back. He didn't, he wasn't acknowledging and stepping up to what he needed to do. He hadn't learned from his lesson. Of course, the judge sentenced him to 7 years, so didn't believe him, didn't want him back on the street.
You talked a little bit about having victims testify. That's, I think, part of the buy-in, and bankruptcy courts that are dealing with these kinds of cases can really facilitate closure for the investors, which will ultimately lead, / victims, which will ultimately probably promote an actual consensual plan and a path forward by being open to letting these people tell their stories. So in the Catholic Diocese case, again, not a Ponzi scheme, but a case where there were allegations of just terrible things having been done to young people. We spent 2 full days it was in the context of a stay relief motion, but we spent 2 full days listening to victims, or I spent 2 full days in court listening to victims tell their stories. And I was told later by Judge Gross, who was mediating the dispute for me, after it was all done, he told me that actually moved the process forward in mediation significantly, because never before had they had an opportunity to tell their story. And I think the same would be true of really anyone who's a victim, whether it's fraud or a tort or whatnot, having a mechanism that allows them to tell their story publicly in a way that doesn't necessarily, you need to be careful, you don't want to prejudice the debtor, but can really move the process forward to sometimes, it's not, I find this with shareholders too, pro se shareholders, it's often not about the money, it's about the grievance.
Yeah.
And wanting to share how they were hurt and share what effect it had on them and how bad it was. And that often is a big piece of what people are after in these kind of cases.
Kathy, do you get the sense people are often come away from the process feeling embittered, or do they come away kind of feeling like, well, I see now all the complexity of this, and this was kind of a fair resolution?
Well, I think mostly they're angry at themselves because they realized they made an investment that they shouldn't have made.
Yeah.
They were going for the larger return than they would have gotten out of the bank. And so they realized they should have, gotten a lawyer involved. And with the elderly, whether it's Arizona, California, Texas, Florida, a lot of those people have retired and moved away from their families. So they don't have their families and all of their professionals that had been their support group for years. And of course, they see this opportunity that's too good to be true, and they decide they're going to jump in it, and plus that their friend at the synagogue or their friend at their church, really said it was a good thing and they'd gotten their money, so they then jump into it. And they find out afterwards that they've just been lied to or shown false financial statements, or it wasn't documented the way it was represented. So they're just angry at themselves. And then in affinity fraud cases, you also have that element of where they transfer the anger from themselves to whether it was the specific attorneys that were involved or the defendants that were involved. They're looking for a face to blame. And so they get to that next stage as well. But in the end, as long as they think that the process has served them well, that the justice has been done to them, and that they're getting the most money they can get, they understand they'll never get 100 cents on the dollar, but at least they can get something back, then they've reached a good result.
Did most of them have a sense there was something wrong? When they think back on it, reflect upon it, they said, I kind of always knew
Well, in some of them, as Joe mentioned, where you've had a business for 30 years and they have a track record and you've known the company all along and you've gotten your money back out, they don't sense that there's any problem. And if they think they're buying like a note and a deed of trust or an undivided fractional interest in a note and deed of trust or whatever it may be that is the real product, if they think they've done that and they've done some due diligence, then no, they didn't see it coming. It's only when you get to the end and the SEC or the FBI has moved in and brought their people and shut the doors and there's a cease and desist order that they then realize there's a problem.
And Joe, I was kind of curious. Are you seeing changes in the since Madoff? Has there been?
I'm not sure that there's changes. The Ponzi is an ever-changing phenomenon where there's a different hook, there's a different structure, there's a different affinity. In my opinion, cryptocurrency is rife for Ponzi's because you're buying something that's in the ether, resident somewhere in some other part of the world. There's no structure. There's no way for you to have any venue to collect or argue if you get defrauded or what have you. And surprise, surprise, a couple of these things have been hacked recently. Have they really been hacked, or did they just realize, okay, we've gotten enough money, we can't get any more to keep hiding this, so let's just say we were hacked and blame it on some obscure hacker somewhere, and we're just running around the world doing what we do. And so I view Ponzi's kind of like an amoeba. They take different shapes depending on what culturally is the norm. What's hot, what's the next area where people want to invest money.
And the difference I see with the cryptocurrency, we were earlier in our preparation talking about trends, is the difference in the age group, because the cryptocurrency tends to be the younger investors, the millennials who are just beginning to think about where they're going to invest and what they're going to do. They're not going to invest in the stock market. They've seen it go up and down. So technology, which they understand and which is a part of their life,
They think they understand.
They think they understand. So that they want to invest in that, and they see it as being something. And it's an investment. It is not yet currency. It hasn't been approved as currency. And of course, it's a form of security and investment, most likely, but that's an issue that's going to be litigated in all sorts of courts, including yours.
Great.
But it's a difference in the
I had my
age.
17-year-old try to explain cryptocurrency to me the other day, and I don't know if it was his lack of ability to do it or my lack of ability to understand. I think it's probably the latter.
Well, and I think a lot of things are changing so quickly in that technology, both with blockchain and both with the actual cryptocurrency, that technology is going to be right up their alley. That's why. Whereas the older Ponzi schemes, what I've seen is with the affinity fraud, it's the older generation. So then you've got the middle section, and a lot of people will continue to try and get the best return they can get on their assets, and they do what they can to try and make it really secure, and they try to make sure that they've protected themselves.
But I think one of the things that's consistent with all of the Ponzi schemes is people have the fear of missing out, and I think that's definitely what's motivating some of the cryptocurrencies, is that people, you see it in the news every day, the different numbers, whether that resembles anything other than what someone paid or maybe not even what someone paid. But there's this idea that there's a wave that's coming, and they don't want to be left on the sideline and talk to their friends. And it kind of a little bit plays into their affinity group is their age group, and just kind of being part of technology and being that age, and sitting around 5 years from now and everyone's saying, oh, I don't work anymore because I invested in cryptocurrency, and not being part of that.
And further, with millennials now becoming the largest subset of the population, as baby boomers are aging off and dying, millennials, that's the new, there'll be a new group of millennial Ponzi schemers, and there'll be a new group of millennial victims.
It's a growth industry.
Yes, it is a growth.
So if you can't make money in real estate.
And the bottom line for the people in the audience is that Ponzi schemes aren't going anywhere. They've been around for 100 because of the Ponzi case, which was like 1924.
Right.
It's going to, and there were Ponzi schemes before that. It's going to be around, and I see, particularly with the elderly people, as any generation gets older and they're looking to protect their investments, affinity fraud is here to stay. I don't know it's going anywhere.
I found it when David asked me to be on the panel. I looked up the history of Charles Ponzi, and the thing I thought was kind of odd about him is he was front page news for years, and the trial was front page news, and he was sent to prison. But when he got out of prison, he started another Ponzi scheme. And you just have to wonder, like, who would say, well, I'll jump in this time. I'm sure it'll all work out.
I think we can rationalize just about anything, and that's the problem.
Yeah.
Is that people can rationalize doing what they're doing to other people. Oh, I didn't mean to steal those people's money. I didn't steal it. I intend to pay it back. But it's that, lack of connect that's there, and I'm afraid that might not be improving in today's society, maybe continuing to be bad.
All right, maybe a good point to end on.
I've got a question.
Oh, sorry.
Ed?
Mark, I was wondering, to what extent has merit changed your underwriting?
So, I mean, we look at all of the cases, that continually come out. And so merit is a good example of the law changing in a way that makes cases where you're pursuing folks who might have received transfers that prior to merit, either it was the law of the land in the jurisdiction in which the case was being pursued, that there would be essentially a defense to the fraudulent conveyance action. And now it's clear, at least when you're within the confines of the merit decision, that you can go after those defendants. So there being clear law on an issue that was a big part of the defendant's reason for getting out of liability, that makes us more comfortable in looking at those cases and seeing them as viable options to pursue litigation finance.
And Judge, are you seeing a lot of motions to reconsider?
I haven't seen anything yet, but I mean, I've been talking. I have a very good personal friend who's basically a bankruptcy litigator in Delaware, and I remember when he told me he'd figured out 364E. Not E, 364. Is that it?
546.
546E. His eyes got huge. He's like, this is the best defense ever. I love this defense. And I called him right after the opinion came out. I go, how you doing? You jumping off anything? And he's like, yeah, we'll see what happens. So I haven't seen it yet, Ed, but I'm sure we will see it. Although maybe not, because those cases weren't being brought at this point. It'd been several years. So it's been a while, and we got to go. It's been a while since we've had to decide those issues because people just weren't bringing them. Right.
Great. All right, well, thanks.
Thanks.